Real people, real opinions, Real Talk Radio. The multi-award-winning Niall Boylan Show.
Let's talk about wills. It's extremely important. And of course, my culture producer reminded me about the field. What's this bit of the field?
This is the widow's field. That's the law.
That's the law.
The common law.
The common law.
There's another law.
There is?
Stronger than the common law. What's that? The law of the land.
The law of the land. There's another law more better than the common law. Well, unfortunately, that's not really true. Unless, of course, you live in the United Kingdom where they do operate in common law. We don't operate in common law. But there's nothing like a good family dispute over a will. You know, there's nothing more Irish than that. And despite this, despite the fact that we all know the tendency falls, you know, wills tend to fall into dispute over land, money, all those kind of, property, etc. And even, jewellery and stuff like that as well. Why do people still not write a will? Well, today we asked you to send in your questions about wills, and we're delighted to have John Costello, consultant at Orpen on the line. Good evening to you, John.
Good evening, Niall. Thank you for inviting me on.
You're so welcome, because we spoke to you during the year last year, and the piece was so popular. For days, we were still getting questions. If you have your man on again, will you ask him a question for me? And it's something that we don't think about. I only spoke to somebody today who's quite young. I don't know exactly how old she is, but I'd say she's probably in her 30s or early 30s. And I said, have you written a will? We were kind of just chatting about things. I said, have you written a will? And she said, no. And I said, well, you have a child, so you should write a will. People just forget to write them, don't they?
Well, that probably is the most common situation when a will should be made, is when parents have a young child or children. There was a case about 40 years ago, I'm old enough to remember it, when there was a gas explosion in a block of apartments in Sandymount, and the two parents were killed. They worked in RTE, and they'd one young child that survived them. They'd no wills. And both sets of grandparents went into the district court fighting over the guardianship of the young grandchild because there was no will made. So if the parents had made wills appointing guardians, that would have all been avoided.
That, by the way, is there any law whatsoever in relation to, your godparents when you get christened? Wasn't there an old adage that they were the ones who would be guardians of you if, both your parents died?
Well, that's a religious concept. There's no legal basis for that.
Right, okay. But the judge might listen to it. It's like, I suppose we don't have, in marriage in this country, we don't have prenuptial agreements because they're not legal in Ireland. But a judge can read it to give them an idea of how you might have been thinking at the time. So I suppose
it depends on the facts of each case. It should be hard to persuade a judge that godparents have legal rights. It would depend on the circumstances. But generally, people make wills when they have young children, when the children are in their 20s, and then maybe when they have grandchildren. So generally, I find that people make wills at different stages in their lives.
Yeah, when life changes, I suppose, when you get married or divorced or married again or whatever it happens to be. Now, here's the thing. Is it true that you don't actually have to go to John Costello or Orpen Franks? I don't want to put you out of business, but that you can literally write your own will and sign it and get a mate to witness it. Is that valid?
Well, you can get a will form in certain stationery companies, and I've come across them over the years. Half of them have been perfect. The other half have caused major legal problems, and some of them have ended up in the High Court. So, in fact, by making a will, a homemade will yourself, the results could be that your family could be spending tens of thousands in legal fees trying to argue the validity of the will in the High Court. Right. For example, that sometimes the intention isn't clear, sometimes it's not signed properly, you need two witnesses, and sometimes, the wording isn't correct. So for the sake of €250, €250 is about the cost of a straightforward will. Mm-hmm. And for the sake of €250,
that peace of
I
mind.
have to recommend doing it professionally.
Yeah. So would you recommend if people get divorced, if they get separated, if their circumstance changes, the will automatically should be looked at and changed, or your will should be changed, even if you're still going to do the same things, but just to make sure all the I's are dotted, etc.?
Well, yeah, certainly after a separation or divorce, normally the former partner won't be a beneficiary, so you'd have to update your will, and presumably the children would be the sole beneficiaries. So that is important to do that. So normally, in fact, with a separation or with a divorce, both parties will renounce their Succession Act rights, so that they would waive their rights to a share of each other's estate in any event. That would be a normal practice.
Okay. So, with a will, for example, does it matter how young you are? For example, what age do you have to be to write a will?
You have to be 18, and you need two witnesses. You need an executor, and in the normal family type will, with two spouses or partners and children, the spouse or partner would normally be the main beneficiary, and they can be the executor as well. And then what would happen is, then if the spouse or partner didn't survive, that everything would go equally among the children, and one or more of the children could be the executor, provided they're over 18. So if the children aren't over 18, you'd have to appoint maybe grandparents or uncles or aunts to be the executors if they're not old enough.
By the way, somebody has texted to me here based on The Field, by the way, that quote from The Field, and he says, Niall, we do operate under common law. I thought it was just the UK that operates under common law. We thought we operate under constitution.
No, we do. No, Ireland and the UK operate under common law. Basically, it's case-made law. It's really law that's evolved through the courts. And so the UK, but we're the only common law jurisdiction now in the EU now that the UK have left.
Okay, so it's based on tried and tested cases, I suppose.
That's right, generally, yeah.
Okay, so what happens if you let's take an example of a mom and dad and three kids, say two teenagers, one is 24 years of age, one is 15, one is 17. Mom and dad both die at the same time. Tragic car accident. No will is made. So what happens? Does the will go into probate, or does it always go into probate anyway?
Well, what would happen is that legally the three children inherit everything equally. They get a third each. Now, if you're under 18, you can't inherit a share of an estate or property or money until you become 18. So the younger children have to wait till they're 18 to get their share. But what would happen is, you see, if there's a house, or if there's a bank account, generally if there's a bank account with over €25,000 in the account, you have to take out probate or a grant of administration if there's no will from the probate office. So normally what happens is that with a husband and wife or partners, everything's in joint names, and if one dies, the surviving partner or spouse inherits everything, and there's no need for probate if everything's in joint names. Now, if both parents die, that doesn't arise. So what would happen in that case is that one of the children who's over 18, or one or more of them, would have to apply for a grant of administration, and that would enable them then to transfer the house into the three names when they're 18, or else to sell the house. And also that normally monies in the bank account or financial institution are frozen until you get the grant of probate or grant of administration if there's no will from the probate office. So you can't, the only funds that can be released from a bank or financial institution without probate are funds to pay the funeral expenses. So everything else is frozen until probate or grant for administration issues, and that normally takes up to 6 months at a minimum.
Yeah, it could take more, because I remember my own father died going back about 7 years ago there, and it was nearly a year I think it took for it eventually.
Yeah, well, there's a lot of delays now in the system at the moment, but it's.
And then there was a question, because he had left a house to myself and my sister. Now, it wasn't a very valuable house, but it was a house nonetheless. There was a question over whether there was going to be capital gains tax on the value of the house going up in that period of a year during probate. Oh God.
No, well, that's a good point, because in fact, it's a good reason. Sometimes what I do actually recommend that if the family home has been sold, I recommend that you sell the family home before you take out probate. You can sell the family home before probate, and then you put in the sale price as the date of death value, and then you avoid capital gains tax by doing that.
Oh, right.
Now,
okay.
it only arises if you're selling pretty quickly after the date of death.
Yeah. Okay, there's loads of questions in here. A lot of them are kind of very similar, right? But there's one that says, I have a property in Spain. Is that covered in my will?
Well, generally your will in Ireland would cover your worldwide assets, and most people just have Irish assets in Ireland and no other assets. But a lot of people, as you know, have holiday homes on the continent. And I always recommend that if you have a holiday home on the continent, Spain or Portugal or whatever, that you make a will in that jurisdiction dealing with your property in that country, because they have different succession laws in the Mediterranean countries, and also it can be complicated if you only have an Irish will. You have to take out probate in Ireland, and then you have to get a translation of the Irish will. And the translation then has to be sent with an official copy of the Irish will to the Mediterranean country, and it delays the whole process. So it's much easier if you have
pay an extra £200 in Spain and get another will done over there. I suppose.
And so your Spanish property will just cover your Spanish will just covers the Spanish property, and your Irish will just covers your Irish property.
My parents are elderly and won't make a will. There are 4 of us, and one of us is actually a solicitor. I think it's a disaster waiting to happen. They have property. What will happen if they never do? In other words, if they don't write a will.
First of all, if everything's in joint names and one parent dies, the surviving parent inherits everything without a will. Now, if everything isn't in joint names, what happens is the surviving parent inherits 2/3 of the deceased parent's estate, and the children get 1/3. And if both parents have died, the children get a 1/4 each. But the problem is that there can be problems to say one of the children predeceased. And there's no will. You see, normally I provide in a will that you leave everything to your spouse or partner. If they don't survive, everything to your children. But then I also advise parents to provide that if one of your children predeceases you, does their share go to their spouse or to the children, i.e. the grandchildren? And so that's another reason for making a will, that you can provide what happens if a child predeceases. So in the case that you mentioned, if a child predeceased and there's no will, everything goes to the grandchildren, and the surviving spouse gets nothing.
Okay, listen, loads. By the way, if anyone wants to send any questions in, you can 087 188 0008. I speak to John Costello from Orpen Franks Solicitors. Now, I don't speak to my dad. I'm an only child. My mum is dead. Will I get anything if he doesn't leave me something? So I don't speak to my dad, and I'm an only child.
Well, yeah, the answer is yes. Every child has a legal right to challenge a will, not if the inheritance goes to a surviving parent, but if both parents have died, a child can challenge the will if they have to prove A, that they have a financial need, and B, that their parent has failed in their moral duty to make proper financial provision during their raising. And
let's just say, for argument's sake, this father who's not speaking to him and his mum is dead leaves and writes in as well, I'm going to leave it all to my girlfriend. Yeah.
Well, first of all, the child has a legal claim because you can't disinherit a child like that. Now, but the problem is the child isn't automatically entitled to a specific share. The child has to.
Now, when we say child, are you talking about somebody
that's over 18? Yeah, okay. Obviously, you could be a child of 60. You know.
Oh, right, okay.
Yeah. So you go into court, but you have to prove that you have a financial need and that the parent has failed in the moral duty, which obviously you have in that situation. Okay. But the problem is you can't, as a lawyer, you can't guarantee what percentage you're going to get. The Succession Act doesn't say what percentage you get. It's up to the court to decide. And so quite often those cases go to mediation. You know that there's a dispute between the beneficiaries and the executors as to how much the beneficiary should get, or the child, the disinherited child. And the court will normally recommend mediation because at the end of the day it saves a substantial amount in legal fees. So you normally settle the case.
Okay, I'm divorced and married again. I have no contact with my former family. Will my wife and kids who are in my will automatically get everything, or can my old family come looking for it?
Well, certainly you should update your will, but if you're separated or divorced, normally there's an automatic provision that both parties renounce their Succession Act rights in each other's estates, so that they waive their legal entitlement to a share of each other's estate. So if there is a separation agreement or a divorce, that would have been done automatically. So the former spouse will have no legal rights to a share of your estate. Now, your children will always have rights to challenge your will, so you can't disinherit one of your natural children.
Mm-hmm. Okay, I am 43 years of age. I have 2 kids. My husband and I are self-employed. What is the best thing I can do now to protect my money for my kids if the worst happens? Well, I suppose right.
Well, I mean, a lot of that's a common family situation. So, I mean, I'd recommend that both parents make wills. They leave everything to each other if they survive. If they don't survive, they leave everything equally among their children. I don't know what their assets are. Of course, if their assets are substantial, you may have to get inheritance tax advice. Because you might want to reduce the inheritance tax. There can be, for example, there is one of the main reliefs for inheritance tax is the family home. If you're living in the family home and you inherit the family home from one of your parents, and you have no interest in any other property, you can get the family home tax free. So that's a huge relief. So normally that's where that happens is if elderly parents are living at home and there's one child looking after the elderly parents, the parents might leave the house to that child, that they can get it tax-free if they've been living there a number of years before the parents die. Now, if there's a large family, I always recommend that everyone gets something. But there is a tax benefit. There is a family home relief in the tax legislation.
My mum is elderly and the government are offering to pay her property tax on the house. She thinks it's a trick and that they will own some of the property when she passes. Is this just a good deal? Well, I think they're probably just putting a judgment on the property, I imagine, is it?
Well, I don't understand that question. I've never come across that situation before. It doesn't make sense to me.
Unless they're putting a judgment on the property for property tax that she owes, which means I'm assuming when they sell the house, it has to be paid.
Oh yeah, it's a revenue debt. So maybe they're putting a charge on the property, but it's like any revenue debt. They'd have to get a judgment in the High Court or in some court against you, and once you get a judgment, then it can be registered as a judgment mortgage against the property. And I'm sure maybe that's what's happened.
Somebody says, can you please explain inheritance tax? The bit about inheritance tax. Is Ireland particularly bad for it? So we keep changing it. Obviously, every budget, it changes the amount of inheritance you can get.
It hasn't changed in the last number of years. And, compared to other jurisdictions, we're not too bad. For example, there's no tax between spouses or partners. So you can win the lotto and give it tax-free to your spouse or partner, a tax, onto your will. So that's very generous. Each child can get €335,000 tax-free. So if, for example, you have 3 children and you have a house worth €1 million, if you're that lucky, you can leave it tax-free to your 3 children because they'll each have 335,000 tax-free threshold.
Now, the tax-free threshold, that's in a lifetime, isn't it?
It's in a lifetime. Yeah,
okay.
That's right.
Okay,
yeah.
So if they got another inheritance from Granny down the road or somebody else down the road, they may be taxed on that.
Well, it won't reduce the inheritance from a parent because because there's different thresholds for different relationships. So in that case, there's only lifetime gifts from parents that reduce your threshold from a parent. So, but you can give 3,000. There's a small gift allowance of 3,000. You could give everyone in your family €3,000 each year without any tax consequences. So wealthy families give all their grandchildren €3,000 each year, and there's no tax consequences at all.
Okay, Aaron in Galway wants to know, he's 37, he wants to write a will, but I'm wondering if any solicitor can assist you to write one, or do you have to go to specific types of firms? Argue quite a lot. Sorry, John, we lost you there for a second. I had no idea what happened. So, John, yes. So, one of the very common questions that's coming in is the argument. In other words, a typical example of some of the texts that are coming in, there's all mixed versions of it, but, my sister is now living with my mother. She's manipulated her. I don't talk to Mum anymore because of my sister, and I know she's got her to change her will. Can I challenge it? So, can they challenge? So let's say the mother's living on her own and the sister or the brother is living with them and they've kind of manipulated them because they're quite elderly, which is, is quite common, I imagine, and got her to change the will and write somebody else out or write another sister or brother out of the will. Can they do that and get away with it?
Well, yes, I mean, there's been many cases have gone to the High Court where there's been undue influence over an elderly relation and their will. You'd have to prove that there's some sort of elder abuse going on. And I understand that the HSE have elder abuse officials, And it's not just abuse in relation to a will, but there could be abuse in relation to finances or psychological abuse or just generally bullying. And the HSE can investigate, the officials that can investigate these family situations. So this may be a situation if there is bullying as well as undue influence and maybe financial
coercive
abuse,
control and all that kind of stuff. Yeah.
It could be a case where these elder abuse officials could investigate the situation. Now, it also may be possible to go maybe to the family doctor, the GP. Or maybe there could be a public health nurse that could call, or and just make discreet inquiries. It's a very delicate and sensitive situation. But if, for example, the will was changed, and everything goes to one child, the other children still have legal rights to challenge that will. At least, even if the will is changed, it's not the end of the road completely. Because there can still be a legal challenge by the other children.
I'm assuming wills basically cause a lot of families to break up and stop talking to each other. And I
know. In fairness, in most situations, from my experience, it's everything works out very well. It's a minority of cases, and the trouble is, we read horrific cases in the media, and we think every family is like that. But in most cases are fine. But the problem is that you see people are struggling financially to buy a house, as you were talking about there. And so, people are more conscious now of their inheritance. A lot of people need their inheritance to buy a house. So people are more sensitive about their legal rights. And, So, but I would think, let's put it this way. When I have had disputes amongst families, and I've gone to mediation, so I can't mention mediation too often, because it's a wonderful way of solving a dispute without spending tens of thousands of litigation fees on lawyers.
Yeah.
So all I would say is that there can be quite a lot of family disputes or arguments, but if the worst comes to the worst, most of the cases are settled in mediation, so you don't end up in the High Court. So that's the good news.
Okay, another one here. A friend died in America. She had a property there and in Clare. She left no will other than to leave everything to her charity in New York City. No one works there now. I think the American lawyers are having a field day. Is there anything that can be done to stop them eating up her fortune? She has cousins here, and that is it.
Well, I maybe would instruct maybe another firm of American lawyers to investigate this, because they need to get an official copy of the will from the relevant probate office. If this charity isn't in existence, they'd have to, the other lawyers would have to make sure that the estate is being administered properly. Because certainly in Ireland, if a charity is no longer in existence, that the law says that the inheritance goes to the charity, to a similar charity. But sometimes they might need court directions regarding, what is the best charity to benefit.
Can you genuinely, let's say you're worth a few million, and let's say you have a few children, maybe your wife is dead, right? And you have a few children, but you don't particularly want to leave them anything. Can you leave it all to the dogs and cats home? You often hear people, I'm leaving my money to the dogs and cats home. Was it Bill Gates famously said he's not going to leave a penny for his children?
Well, no, I mean, in theory you can, but I mean, the problem is that it creates more problems by doing that, because the children then challenge the will in the courts, and, it doesn't achieve anything. But I did have a case where a father, he was worried about leaving a substantial inheritance to his son because his son was totally irresponsible. Didn't believe in doing a day's work, and so we had a trust. We created a trust for his lifetime. The father put the money into a trust, had two friends or relations that would hold the money on trust for the son to preserve it, so that it wouldn't be it would be spent wisely for his benefit. So sometimes you can have a trust if you don't, because children, as anyone can have addiction problems, gambling problems. And so a trust can be a very useful mechanism whereby the children can benefit from the trust fund, but it's controlled so that they can't misspend it,
In regards to, I suppose, the idea of, going to court and disputing a will, and I'm sure you've taken or you've helped with many a case in relation to that, are those cases hit and miss? Because you said, for example, that the child would have to prove that they haven't been provided for. So if a child has been provided for, let's say they're married, they have 2 children, they have their own house.
Not properly provided for.
Well, let's say the child is married with 2 children, has their own good job, and everything else, and is moving on with their own life. Well, then surely, by the very nature of the fact that maybe the father wants to leave the money to the girlfriend or the dog or whatever, I don't know. But surely if the child has been provided for, they don't have a legal challenge, or do they still have
No, they would have to have a financial need. And the court looks at the position of all the children. So that if you're the wealthiest child in the family, you're probably not going to succeed to a challenge. So it depends. The court has to look at the family circumstances of all the children. At the date of death, the relevant test is, what were the circumstances of all the children when their parent died? So each case is different, but certainly the wealthier you are, the less likely you are to benefit substantially from a court challenge.
My producer just said as well, with regards to what you said about this generation being worried about buying property, there was an article in the Mail in February that said half of Britons have gone online to check what their parents' property is worth, 2 in 5 people relying on their inheritance to help them buy a home, and the average amount they expect to receive is 195,000. So in other words, they expect to receive 195,000, and they're obviously very keen to find out. We're almost wishing our parents away, which is terrible. I mean, it is shocking. But look, if people want to pop into you at any stage, Orpen Franks, you can go in there and you can sign up your will, and you should do it. I know it's a very morbid thing, John, and people don't like thinking about it, but it's really important, isn't it? I mean,
well, actually, you owe a duty. If you're a parent, you have a duty to make a will to benefit your family in the best way feasible.
Of course.
I would nearly say it's a legal duty of every parent to do it.
Yeah. And do you end up arguing with people in the office by saying, well, you can't do that now, only you have to leave them something, or you have to...
Well, I mean, let's put it this way. I mean, we're not supposed, as solicitors, we're not supposed to be making the will for the client, But I mean,
you give them advice.
Well, what we might do is point of advantages and disadvantages of certain arrangements, if you know what I mean.
Yes,
we'd have to point out pitfalls if there were pitfalls in a certain position,
But there's a question just come in there. Is now, what happens if the parents are in social housing and the parents die? Nothing, David. The state own the social housing. You don't, so you're not getting it. If that's what you're
right.
thinking. But listen, thank you very much indeed, John Costello from Orpen Franks, and I appreciate you coming on the air tonight and answering all those questions. And if you're welcome. If anybody wants more information, you can go to orpenfranks.ie.
Real people, real opinions, real talk radio. The multi-award winning Niall Boylan Show.